my PowerPoint slide. Okay. Okay. All right. Can everyone, can you see my copyright basics in history? Not yet? Okay. Let me, sorry about that. Just pause for one moment here. Okay. Now? No? Okay. I'll try one more time. Making sure I'm sharing the correct screen here. So. Okay. Okay. All right. Thank you. All right. So today the title of our Exploring Copyright Without Fear Masterclass series is Copyright Basics in History. I'm Christy Padrone. I'm the Scholarly Communications Librarian. Most of my career has been in instruction, so I've been teaching people how to use the library, its different resources, and how to do research. And within the last year, I've segued into scholarly communications and discovered the broad world of copyright and hope that we can share that with everybody here in the library. And also presenting will be Larry, who just introduced himself.
Christy, you're
Yes.
showing, are you meant to show the Padlet screen, or are you on the slideshow? Because you're showing Padlet screen right now.
Okay. All right. Okay. Okay, are we seeing the objectives?
Yes.
Great. Okay, sorry about that. So, okay, so the 4 takeaways that we hope you leave with will be to outline a definition of copyright and where it applies, identify copyright law, its sections and ways it's interpreted. Now, please don't have fear here. We're just really going to show you where the copyright law can be found, some of its broader sections that apply to us, and then just a very, very basic chat about how it's interpreted. Then Larry's going to go into describing the historical development of copyright. It is interesting and also necessary to know about how copyright does have changes over time. And then finally, we wanted to leave you with some authoritative sources for information on copyright, so that once you're done with this recording, you will be able to have some information sources that you could lean on to help you or help you help others with copyright. Just a little housekeeping. I ask a question: how do you feel about copyright basics or copyright in general? I created a Padlet page. You can open a new browser window or use another device. And basically how it works is you can double click on a page and type your thoughts. It will look something like this. So you could type your thoughts, your ideas, anything else that comes to your mind. It's anonymous. I don't know who says what, but you're more than welcome to say you wrote it if you want to. But if you have any things you'd like to jot down or questions you'd like, we can go back to this, and then we can maybe come up with some new ideas or ways to explain it or things like that. So we got that as a way for you to scratch out your thoughts if you'd like. Okay, so now to go back to our slide. All right, so what we'll go over in this section are the copyright basics, like the definition, what is work, what are the rights and protections people have for copyright, and then we'll introduce the concept of interpretation of copyright law and case law. Now, copyright is defined as legal protections and rights for creators who make an original work in a fixed medium. So to explain what that means, I'm going to break it down by the red letters on the slide. First, I'll focus on the word work. So work means what can get protection, what kinds of objects or things can get a copyright, or protected by what copyright gives. And these are from the copyright law, include the following. You've got literary works. So it could mean books, it could mean literature. It could also mean anything scratched out on a paper as well. And computer programs and the scripts are also a part of what is constituted as a literary work. So that's protected under copyright law. Musical works are also preserved, so whether it's sheet law or the musical performance itself, it can get copyright protection. Dramatic works like movies, stage, theater can be copyrighted, and so can pantomimes and choreographic works. So remember those people, or you've probably ever watched the break dancers from the 80s, and now they can get their work copyrighted too. Pictorial, graphic, and cultural works can be copyrighted. So pictures that you take, things that you draw, something that you make on like an architectural or design software can be protected by copyright, and cultural works can be protected by copyright too. Then you got motion pictures and other audiovisual works. So people make a lot of multimedia art nowadays, movies, little recordings. If I record my dog running around chasing her tail, I can copyright that image if I wanted to. And you could also record, you could also have sound recordings and architectural recordings that can be copyrighted as well. Basically, what all those things or works have in common is that they're in a fixed medium, and it's defined as a work in a tangible form. Can you look at it? Can you touch it? Can you hear it or see it? Once something is in a fixed medium or a tangible form, it qualifies for copyright protection. Intangible things cannot get a copyright. So what could those be? An idea on their own or by itself cannot get a copyright protection. I think it would have to be written on paper, published, captured as an image or something for it to get a copyright. Recipes, for instance, cannot get copyright. Neither can measurements, facts, or processes. Those cannot get copyrighted either. And principles and discoveries also cannot. So if somebody were to discover a new planet or a solar system, for instance, well, a scientist or their team can put a name on it, but they can't necessarily say it's theirs and this is legally protected as being theirs. So basically, ideas, thoughts, things that are intangible cannot really get copyright protection, and facts, because you really can't own facts like 12 inches make a foot, things like that. That's not protected by copyright, and I'm kind of glad it's not too. So another part of the copyright definition is rights for creators. So copyright defines what creators can do with their work. So if you make something, you could also reproduce it or make copies. You can also make derivative works. So I have a goofy image of my dog running in circles, chasing her tail. Well, if I find some copyright-free music and do like a mashup of my dog with music and goofy things, you know, it's a derivative work of the original image of my dog chasing her tail. I could do that. I can distribute copies. Copyright holders or creators can also display their work publicly, like in a gallery or someplace like that, or they could perform the work publicly. And for people who focus on sound, they can perform the work publicly using digital means of transmission. So somebody who's a recording artist can play their music on YouTube or Spotify or something like that. And then the final part of that would be the legal protections in that definition. Now, the legal protections are outlined in the current copyright law of the United States. It's the United States Code, Chapter 17. Here's where you can find legal definitions, parameters, or exceptions, which are also known as exemptions. It's kind of a synonymous phrase. Copyright is actually automatically granted once an idea is in a fixed, tangible form. That's really something. That means a person doesn't necessarily have to apply for a copyright for it to get copyright protections. Like, for instance, I took a picture of my goofy little dog. The moment I took this picture, it had a copyright. This picture of my miniature dachshund when she was a puppy belongs to me. I own the copyright for this image. So I don't necessarily have to go to the copyright office to get it. I have it and it's mine. However, registration or getting a copyright through the US Copyright Office is recommended for legal or commercial purposes. So if I want to make money on it or for legal purposes, I can, but it's not really mandatory. Something else that is part of the legal protections of a copyright is that copyright is held by a copyright owner or multiple ones, and the copyright can be shared or transferred. So for instance, I could transfer my image of my dog Marley to somebody. I can sell this picture to somebody for say $500 and they own the copyright for this image of my dog Marley. This happens also with our journals and our articles that we get in the journals and the serials. Whenever an author has an article that they have published in a journal, a lot of times they sign away their copyright to the publisher, and the publisher has the copyright and can do what they want with it. So we'll go over that later, but that's another example of how the copyright can be transferred. And finally, what I wanted to cover for the legal protections is that a length of time of work has protections depends on the following. So a textual work will have a certain period of time where it has copyright protections, but music will have a different span of time, and that has to do with the law. We're not going to cover that right now, but I wanted to make you aware that the type of work will depend how long it has copyright protections. Another influence is the year it was created. So this picture, my puppy, was created, I think, in 2009. So I'd have to take a look at how long would this picture have copyright protection since I did it in 2009. And then also the country where the creator was when it was created also has a bearing on copyright. So now we'll go to interpreting copyright, and I want to assure you this is just an introduction. I'd like to say that it does take a little while and quite a bit of time to learn copyright and to understand it before you could really start to interpret it, but I do want to get your feet wet and introduce you to what you can expect in doing that. Interpreting copyright is never a yes/no answer, but rather it depends. So whenever Kim or Nikki get copyright questions, like if Kim is fulfilling an interlibrary loan request, she can't say just yes or no. She has to think about certain factors about whether or not something can be reused through interlibrary loan, and Nikki would be doing the same in her work with course reserves. So what it depends on are three broad things: is the work itself. So what kind of work does somebody want to reuse that's copyrighted, and what is its copyright status? The details of use will also affect how copyright is interpreted. So it depends. What this means is, what is your purpose for reusing a work? Does somebody want to borrow Miss Marley's image to teach a class and to show a cute picture of a dog, or to illustrate an example? Or do they want to commercialize it and put it on t-shirts? So how copyright would be interpreted depends on how they want to use this copyrighted item. Also, how much of it wants to be used, or where it will be used and for how long. So those details of use are a very big factor in copyright questions you might have, or copyright scenarios that you may have on your job. And then case law is a third aspect of how copyright is interpreted. What this means is the courts have had a lot of copyright cases. You know, somebody wants to sue somebody else because of copyright infringement, perhaps. Well, the court decisions really suggest how nuances of copyright law can be interpreted and applied. So we got the law that gives us some guidelines. You got a work that you want to reuse, you got some details you want to reuse, and then you got case law to kind of like, you know, how did the courts interpret this recently? So those are some things that you'll use to and apply in interpreting your copyright. Now, one thing I wanted to add about case law is to be aware, not beware, but just be aware, read about the cases. Interpretations will vary by court decisions. Tom, I think, will talk about this quite a bit in his fair use presentation that we're going to have at the end of the month. But courts will decide differently on the outcomes of cases, and will have various ways that they make their decisions. But it's good to know the nuances that they look at to help guide you with the copyright question. And also it's good to follow them to see how the courts interpret it, because they do change with time, and the little details that come up in the case are very good to help you with interpreting copyright. So just to give you a couple examples of some very famous cases, fair use and parody actually was defined quite a bit, and it originated here from South Florida. How about that? Luther Campbell, also known as Luke or Luke Skywalker was his stage name, was in a lawsuit with Acroft Rose Music Incorporated. They were the publishers of Roy Orbison's song, Oh Pretty Woman. Well, in the late 80s and early 90s, he did a parody of the song, and the debate, the court case went all the way up to the Supreme Court, but it really has been a definitive case on allowing copyrighted works to be used for parody and also fair use. And to go into libraries, we've got the library exception in the fair use case with Cambridge University Press and other publishers who sued Becker, who was the president of Georgia State University. What happened in this case was an interlibrary loan department at Georgia State University had digitized some materials, and the publishers had sued Georgia State University, claiming that it was infringing on their copyright for the works. It was a very long case. It went a few years in court, back and forth, but ultimately it was decided that the publishers had, like, I can't remember the exact number of how many copyright infringement instances it recorded, but the courts decided that very few, like maybe a handful out of the dozens that they asserted, really did not follow, fair use. But those two cases are examples of how case law and the courts interpreted copyright. All right, so I promised I wouldn't scare you too much with too much law, but rather just give you a brief introduction to some of the foundational things that influence copyright scenarios and decisions you could make. The copyright law is a pretty dense work, but what I was able to do here was break it down in these main sections. It does have certain sections that you can expect to find certain parts of the law, like for instance, section 101 is the definition. I basically used that definition in introducing copyright. And then you've got other sections. The sections where you see the red asterisks are the ones that apply most to the libraries, like section 107 is the fair use. It's a very, very brief section. I think it's barely a paragraph long, but it talks about how copyright can be used, copyrighted goods can be used for other purposes without asking for permission and without it being infringement. Section 108 is something that the interlibrary loan people look at a lot. It's called reproduction by library and archives, and I believe special collections in the digital libraries would probably lean on this part quite a bit. But this section goes into ways that libraries can reuse copyrighted works within the scope of the law without violating copyright. That's become very challenging nowadays because now more things are going digital, and a lot of the things that we have are licensed or leased to us, so to speak, or the library subscribes to them. So 108 is very wildly shifting part of copyright law. Section 110 is known as exception of certain performances and displays, and this talks about how copyrighted works can be used in teaching and learning settings. Section 110 Part 1 is known as class use, or also known as a class use exception. I won't describe that much, but it basically, like I said, describes how can copyrighted works be used in a face-to-face classroom setting. And then you got the Teach Act. FAU does not use the Teach Act because there's certain provisions and requirements that the institution has to have in place to do that. But if you were to move on to some place that does use it, it's good to know. And then you got Section 121, which is the reproduction for blind or other people with disabilities. So copyrighted works can be digitized, say, to be reused for blind people or people with visual impairments, and Section 121 outlines that. And then finally, you got Section 1201 or 1201, and that's called the Circumvention of Copyright Protection Systems, known as the Digital Millennium Copyright Act, which is kind of complicated, but in a nutshell, it gives internet service providers certain protections in copyright, but also allows people to circumvent things in place, to especially digital things, to be reused for teaching. But it's a very complicated section and kind of tricky to apply. But basically, there is a section of copyright law that says, yes, there are very limited reasons that locks can be tampered with for copyrighted goods. You know, it sounds kind of like what, but it's complicated. Okay. All right. So were there any questions that came up in the chat? I can't really see anything. So
No,
I don't know.
there's currently no questions, Christy.
Okay. All right. Okay. And yes, your feedback is very welcome too on the Padlet, because that way we can know how we can make these more useful for everybody here. Okay. So before I conclude my section and pass the baton to Larry, I had some scenarios that we can think about and try to apply our what we just learned about copyright. Okay, but I'll kind of pause on that for a moment. I do have a question. What is the Teach Act? The Teach Act is a part of the copyright law that allows certain works to be used in online settings. So for instance, if somebody wanted to stream a video in a class, the Teach Act does give certain like guidelines, well, not guidelines, but like kind of like a framework for how it could be used. It's ultimately up to us to interpret it. I'm afraid the copyright doesn't really give us specifics, but rather like a framework, and then we kind of like think about the facts and does this apply? Does this work? So the Teach Act is something that allows people to reuse online things in online settings. And there's certain requirements that have to be in place for an institution to have the Teach Act, to be able to use the Teach Act. So Teach Act is really something for educational settings, teaching settings, and they want to reuse online things like movies or maybe even ebooks and things like that. So that's what the Teach Act is. And the reason why FAU can't really use the Teach Act is because we don't have a copyright. The university itself does not have a copyright policy. That's one of the requirements for having the Teach Act take place and take effect in an institution. And the institution also has to provide copyright information sources to its teachers or staff or faculty to do that. Now, we are building a collection of that, but the university at large hasn't really orchestrated anything like that. So that's why it doesn't quite apply to us. So that was a question that came in. So thank you very much, Deepa, for that one. Okay, so I don't see any other questions here. Okay, so we'll get a chance to apply some of these basic fundamentals that we just talked about. So here's a scenario or a question we might be asked. Number one, Professor Proficient has a great idea for a process and wants to get a copyright for it. What are some things she would need to do for it to get copyright protection? So go ahead and put your answers in the chat if you'd like. What do you think Professor Proficient would need to do to get a copyright? So there's no grades here. And the interesting thing about copyright is, like I said, it's not a yes/no answer, but it depends. So what are some things that Professor Proficient would like to do to get a copyright? Okay, so put it in a tangible format, write it down, put it in a fixed medium. Yep, that's what she would have to do. Yeah, that is the thing. I mean, copyright, first of all, it has to be a tangible form. So even if she didn't want to write it down, but she wants to record herself, with her phone talking about her great idea, it's a tangible form. She made a recording about it. So yeah, she could do that. So like we said, ideas alone can't be copyrighted. It has to be put in a tangible form. This also applies to issues of intellectual property, because you always hear snarls about researcher A had a really great idea, but researcher B wrote an article about it and got all the glory. So shouldn't researcher A, get all the glory and the fame and the perks for it? Well, in some ways you would kind of say no, because researcher A didn't write it down or didn't do anything with it. So that's kind of a sticky issue with intellectual property there. Although Professor B can say, thanks to researcher A for giving me this idea, or, give it acknowledgement, but that's kind of an issue. Tangibility and documentation are such big things in law, period. Okay. All right, so thank you for that. All right, so question 2. Sammy's student created a cool image for the cover of his upcoming self-produced CD of music. What should Sammy apply for a copyright for the image? What are some basic considerations he may want to make in his decisions? So, okay, so he made an image. Doesn't really matter how he made it, but it's in a tangible form. And he just made a CD. Okay, so Deepa asked, is he going to sell it? Well, yeah, if he chooses to sell it, that's one consideration to think about, if he should copyright his image or apply for a copyright for his image. So there's a commercial consideration that Sammy may have in his getting a copyright. Image and songs, so he should probably apply for a copyright for the songs too. Absolutely. I mean, he might be the next big deal and not know it. It happens a lot, actually. So that's definitely something I didn't think about when I wrote this question, but for sure, yes. And what are some basic considerations Sammy may want to make in his decision? So one of it is, does he plan to sell it, or is it like a CD that he just made to celebrate his parents' anniversary? And he doesn't plan to make money, that's a consideration. Dawn asked, is the cool image exclusively his? Does it contain other parts of copyrighted content? That's a consideration too, actually, yes. Could anybody think of why, whether if the cool image is Sam's or if he used other parts? It's like other images made by other people.
One thing that would probably have to go before a court. The person who owned the other images that were copyrighted would have to then take him to court if there was any issues or questions about that. Because if an artist or creator takes parts of an image and recreates and creates a new image, that in and of itself is a new image. But again, that then will fall on the eyes of the court and the ears of the court to decide how much of the original work content did Sammy use to create that new image.
Okay. Yeah, yeah. So this is true too. I mean, if Sammy did use other people's work, he could be taken to court by the creators of the other images if he did in fact use that. However, he could also ask permission too. People can ask other creators to reuse their work and talk about the limited circumstances or whatever conditions that or details that he plans to use of the work. Mm-hmm. And that's, yeah, and then Ken says something like if he used copyright-free images, that would kind of eliminate the issue about using other people's work. That's true too. We definitely hope to cover something about copyright and images in the future. Deepa had asked, what about vectors? That's a good one. If he used vectors, I do know that if you use images like clip art, you don't have to worry about copyright because it was part of the product that you used to make a document. So vectors might be interpreted a similar way, like if you used Adobe Photoshop or something like that and used vectors. I don't think he'd have to ask Adobe to reuse that because it's a shape and you can't really copyright a fact. And I think a shape might be able to be constituted as a fact, you know. So, but that, wow. But I mean, these are really good questions and comments because I like to think it's introducing us to some of the nuances. I mean, but it looks like a lot of you are thinking about the finer details, not just yes, no, but what else, you know, so thank you. Brian Work had just said, think about trying to recreate the cover of the Beatles' Sgt. Pepper's Lonely Hearts Club Band album today. With all the likenesses and images today, it would be a copyright nightmare. Yes, it could. Somebody could contest the issue of fair use. I'd rather not talk about that right now. That'll take us down another rabbit hole pretty much. But when Tom talks about this at the end of February, on February 23rd at 1:00 p.m. to be exact, we could talk about fair use, and maybe somebody could get away with doing something like that in fair use. It's very, very possible. So. Okay, well, thank you so much. That was a good discussion, chat about that. All right, and the final one. Lenny of Cirque's adorable sugar glider is an Instagram star. Now that Lenny has amassed thousands of pictures of his famous marsupial, his friend Lana in collections suggests he create merchandise for the extra money and to help pay off his student loans or get a new car. Explain why Lenny may or may not be able to do this. And in case you're wondering, that's a sugar glider. They're about this big. So, what do we think? Why could Lenny, let's see. Well, if Lenny wants to create merchandise for his sugar glider, I didn't come up with a name for him or her. What are some things we could think? What are some things to consider? Well, first of all, the sugar glider has pictures. So we've got a tangible image of this little thing. It's kind of like a combination between a mouse and a squirrel, and it's like a rodent-like marsupial.
I think the first question Lenny would have to ask himself, Chrissy, is, or we'd have to ask is, are the pictures taken by Lenny? Just way I interpret or understand when it comes to photographs, it's who took the photograph of in this case, the creature. If the pictures were taken by somebody else, then technically that person who took the photo would have the copyright clause under the, since they took the photo. But I think as long as Lenny, if he took all the photos himself, I think he's good to go.
Okay, so yeah, I would say as long as Lenny uses the photographs he had taken of the sugar glider, okay, he could use those for sure. Now Lana says, dude, I know you're broke. You need to make money. Why don't you make like a sugar glider calendar or a sugar glider, screensaver and do that. Do we think Lenny should apply for a copyright? Okay. Ken says he will be using the pictures for commercial purposes. So Ken says yes, he definitely should apply for get a copyright of his sugar gliders images. Okay, so another part I asked, why may he not be able to do this? So, well, Larry had mentioned that Lenny would have to make sure he's using his own pictures. So if his partner were to use, if his partner took pictures of the sugar glider, probably wouldn't be a great idea to use his partner's pictures, perhaps. There's a really crazy case, and this is a very true story. There was a guy who was taking wildlife pictures, I think in Africa. And he put his camera down and stepped away, and the monkey took a selfie. I can remember it was something like a monkey or a chimp, but I guess the chimp was curious and looked around his equipment and looked into the lens and played with the buttons, and somehow he had taken a selfie. A monkey or some sort of primate had taken a picture of a selfie. And a question came up about, well, who owned the copyright for that picture? Because the photographer didn't take it, the chimp did. Would the photographer have the copyright for that picture, or would the chimp have the copyright for that picture, or who? Would anybody care to take a quick stab at that? That it's kind of a trick question. Sorry about that. But, well, they decided that it would be in the public domain because animals really can't have legal rights of property. Who owns the equipment? Well, it was the photographer who owned the camera. True. Dawn and Deepa are saying that, well, what about the equipment? Wouldn't it belong to the photographer because he owned the equipment? An argument could be made for that. I mean, it became tangible because of the equipment, but it really wasn't the creator. It wasn't the photographer's will to do it. That's wow.
Yeah. Well, go to on that aspect of it. I think, like I said, there was. I mean, a few years ago, for those who watched Oscars, there was a big, group of celebrities, and they took a massive like selfie together. And so the question came up afterwards: who owned the rights to that photograph? So a lot of people said, "Well, whose phone was it?" And from what I gathered and read on that particular incident, it's not that it's whose device it belongs to; it's who actually snapped the photo. That goes before one judge, and it has one different ruling, and another judge has a different ruling. But at least the way it was interpreted then was it was based on who took the photo itself, not the device. That who owns the device.
Well, yeah, that's a good point. When you got multiple people in an image, is it the device? Is it the person who used the device? That's a good example of the scenario too, about the primate that took his own picture. And I think the court ruled it's public domain because animals don't have rights here. Oh my, and then Tiffany, so I'll just conclude with a couple things. Tiffany said she posted a picture of Agatha's first selfie, and now it had her thinking she may have overstepped her posting it herself as her own property. Well, Tiffany, since Agatha is a minor, I think it's technically yours. When she turns 18, that could change, but since she took so I don't think you have to worry about that. Yeah, that'd be kind of sad if she sued you before she turned 1. But um, and then somebody else had a comment going back to Lenny's situation. If somebody else did sugar glider merchandise, would they be able to distinguish from Lenny's? That might be an issue of branding, maybe. Like maybe Lenny should have some sort of brand next to it. But that's a good question about what distinguishes things that look alike. That's wow. I'll have to. That's going to be put on my burner for mysteries like that. Yes. All right. So thank you guys for contributing to that interesting discussion. So I'll pass the baton over to Larry, who'll go over the copyright history, origins of copyright law in the US, the evolution of copyright law, and what's covered in recent developments. So like I said, it's not so much the super fine exact details of everything to focus on here, but the what that has changed and how it changes over time. So I'll stop my share. And then Larry, take it away.
Okay. Hello. Okay. Share screen, PowerPoint. There we go. Okay, so as Mike Christie said, I will be doing the next section on copyright history, looking at the origins of copyright and where it began, and how it has evolved over time, and what the current recent developments are, what the road it's going down now. So where did it begin? Well, unlike the Big Bang and the creation of the planet, copyright actually has a beginning, or at least our version of copyright, which was first put in the Constitution in May 31st in 1790. But like many of the political signs, how we shaped our Constitution and our political processes comes even further back, dealing with Britain's Statute of Anne. That in April 10th, 1710, Parliament of Great Britain passed the Statute of Anne, and the statute basically provided copyright regulation by the government and courts rather than allowing it up to private guilds. So prior to that statute, private guilds who were hired to transcribe documents and put things together for government use had control of the documents and who could use them and how they could be monitored. But that all changed with the Statute of Anne in 1710. So again, here we are in new countries and the creation of the Constitution, and we put that in the Article 1, Section 8, Clause 8. And as it says, Congress shall have the power to promote the progress of science and useful arts. Very open, very vague. By securing for limited times the author and inventors and exclusive rights and their prospective writings and discoveries. Like many things in the Constitution, is very flowing, very flowery in writing, and left up a lot to be interpreted. So here is the very first item to ever receive a copyright under that new clause, John Churchman's Magnetic Atlas and Variation Charts. A little bit about John Churchman. He was born 1753 to 1805. He was an American mathematician, surveyor, map maker, and so for many years he held the official post of surveyor for Chester, Delaware, and other parts of Berks and Lancaster counties in Pennsylvania. So his creation here, he began to find issues with problems with how seamen could find and figure out the longitudinals of the sea. So he began to put his map skills together. He created this work. As you can see, the book on the image on the right is the actual document itself. It was a physical book. And as the book opened up, you would have charts that pulled out. So again, this was the very first item that had been copyrighted in 1790. So as we begin to see, as our young nation begin to grow, tangible items and things have become invented. the very opening to interpreted copyright law had to begin to actually be honed into items that were created. So here's a list of and the dates when certain items and certain types of mediums, excuse me, were begin to be considered for copyright. So like in 1831, we see the copyright extension changed from 14 years to 28 years. And as we know, it'll change, it come to change later as well. Now in 1865 is when we see the copyright to begin to copyright the tangible medium of photographs. Now to understand the history of photographs, the first photographic material or medium was in 1839. And Lincoln was first photographed in 1846, but yet they didn't start to copyright anything that was considered a photograph until 1865. And then 1895, we see the government publications that are considered no longer able to be copyrighted. So anything that has been written, published, created by a government entity is now open for all citizens to use with no issues or worries about copyright. So here we see the very first case that goes before the Supreme Court, March 19th, 1834, the Wheaton versus Peters case. So in this case, the long story of it, there's a short story of this long, interesting case, as I did some research on it, was between Harry Wheaton, who was the third reporter of the Supreme Court, and his replacement, Richard Peters. And what happened is the court reporters for the Supreme Court, it was their job to take all the opinions, all the information that, as for each case that went before the Supreme Court, and they're the ones who took down the notes, the details, the start to finish of how the case was ruled on, assented opinions, dissented opinions. It was left up to them to publish those works. Now, publishers of the courts weren't paid much back then, and it was also, so it fell on their they had to pay for it to basically have it published. So that was one way of how they made back their money. Wheaton was very meticulous. He took down notes on everything and he had them published. Wheaton stepped down, Peters took over, and then Peters decided to revamp those items to basically turn what was like 24 volumes down to 6. He left out a lot of information. You know, he felt that wasn't important. He only wanted to focus on the opinions of the cases and left out a lot of the, the facts and how they were cases were argued. And then the case went before the Supreme Court because Wheaton felt that those items were copyrighted based on his creating the documents. And again, this was infringing on him from making a profit. The manual, as I said in the previous slide, government documents weren't considered or copyrightable up until 1895. So this was the very first case dealing with copyright to go before the Supreme Court. So now we start to see other items that were and when they were copyrighted. So here we see Leaves of Grass. If those who don't know, it's a collection written by American poet Walt Whitman, who lived between 1819 and 1892. And each poem loosely is connected and represents in the celebration of his philosophy of life and humanity. So here is the very first copy that he copyrighted on May 15th, 1855. The interesting thing about Walt Whitman is that he often rewrote and revised and re-edited this particular poem. He's got many different versions that are out there. To use a modern analogy, it'd be like George Lucas, who redid the first 3 episodes 4, 5, and 6 multiple times, adding new scenes to it as he felt a way to tell the story better. But this was the first document, one of the first poetry or written work to be published by Walt Whitman. Here we see in August 18th, 1856, where they begin to copyright and protect plays of performance or dramatic works of art. So here's a composition that was created, and it's right to, they also allowed you the first time to have the right to public performance. So that these are things that were, on stage shows, theater, could now be copyrighted and protected. Even the Statue of Liberty. So the French sculptor, I'll just say Frederick Augustine, I won't pretend to butcher his last name, registered the Statue of Liberty of Independence in both photo, model, and artistic rendering of the statue before as it was getting ready to be built in New York skyline, as you can see here. It's copyrighted, so they could not change, or no one else could come and redo the statue, both as in the island format as for how it was built and structured. So I thought that was interesting that even the Statue of Liberty, a gift from France, though it's been copyrighted in the United States, so no one else can. Obviously, we can see many miniatures in those gift shops we go travel around New York, but it is copyrighted in August 31st, 1876. January 6th of 1897, we begin to see the first rights of musical compositions. Now, while you can't copyright a note of any composition, once the composition is put into full created as far as the words and the music behind it, you can start to copyright it, and we see it in 1897. It also protects, and I thought this was interesting, it also protects unauthorized public performances. So composer A creates a work and it's been copyrighted. Another group down the street cannot perform that in public unless he had permission, or they had permission from the original composer. And obviously that money would be in licensing and things like that would be an issue between the two parties. But January 6, 1897. Here we see the establishment of the first copyright office. So copyright is an arm of Congress, and it's always was originally handled through the Library of Congress. But in 1897, February 19th, 1897 is when it officially becomes its own entity within the Library of Congress. It's not, just part of it haphazardly. It's its own working department. So now we move in, and that was the 19th century. I do apologize, but not mentioned that earlier. But now we're into the first half of the 20th century, and here we see Teddy Roosevelt, in 1909, signing into law the Copyright Act on May 4th, 1909. And this was at this time, this was the third general revision of the copyright law since its original passage. So what do we see here? With the revision of the law, we start to see things that become copyrightable, things like posters. Things like, you see the Barnum and Bailey posters. This is from the Stryker family poster, circus poster. Anything that was a commercial entity that was being promoted in a form of a poster could be considered now copyrightable, and those who infringed upon the similar design or likeness could go before court. So things, like I said, circus posters, billboard advertisements, and eventually the movie posters that we see today when we do go to a theater after COVID are copyrightable works of art or works of tangible mediums. Oh, excuse me. So here, this was an interesting one. So on February 24th of 1908, we see the perforated piano rolls. So those who are familiar have seen in the old Western movies, the pianos that play themselves, and they have a roll of musical that's played through the mechanical piano. They now become copyrightable. So they're not copywriting the actual music that are on the rolls, but the roll itself and its creation and design is now copyrighted. So I thought it was interesting because could have two copyrights dealing with the same song. One of the composition of the music itself, and then also the copyright dealing with the actual perforated piano roll playing in the piano. So here we begin to see, and this is 1912, August 24th, 1912. This is an image of an Edison kaleidoscope record of a sneeze. right? Doesn't look like much, but it's actually the very first what they considered a motion art, motion pictures. So, and this, well, the picture is registered in 1894. It's the beginning of motion pictures. We'll see much later as films begin to become popular. Motion pictures will eventually be able to be copyrighted, but this is the first form of a motion picture to ever be been created was copyrightable in 1912. So now we are in the second half of the 20th century, and here we begin to see the early stages of Congress as early as around 1955 to begin to relook at the copyright law, begin to discuss in the halls of Congress to decide, if it needs to be updated, needs to be reviewed. As we've seen, in the first half of the 20th century, a lot of tangible mediums have been incorporated or invented, and what new items have been created since then.
Larry, can you pause?
Yes.
Can you go back to that real quick?
Sure.
I just wanted to just add something to that slide.
Mm-hmm.
Later in the series, we will talk about how to determine a copyright, and there are tables out there that can help us determine if something is still in copyright. And one of the weird complexities is you'll see in these tables to determine if something is copyrighted is first they ask you, when was the work made? Was it made in 1950 through 19 whatever? They'll kind of give you different ranges and then give you a date, and it's all a little different. So when I reviewed these slides before the presentation and saw this one, I'm like, oh, so that's where all these weird dates came about, like when things fall out of copyright protection. It's because of different revisions like this that have been made since the 1950s, more or less. But Larry will talk about that a little bit more when he talks about the Sonny Bono Copyright Act, that it's popularly known as. But when I saw the slide, I'm like, oh, that's why copyright protections on things are so different. I did not know until recently. So thanks, Larry.
Oh, you're welcome. Yeah, as Christy said, the copyright, depending on when it was created, the tangible medium was created. The jurisdiction of the law will decide on which part of the copyright, of 1909 or forward, when it is protected. Also, there's many movable parts, as those are, like Christy mentioned, Sonny Bono. There's the whole issue with Walt Disney and extensions and things like that. So copyright is, while it's very fluent and there's a lot of gray area, in some cases it is black and white depending on which version of the law it falls under. So here we see, this is when the law gets signed into, the copyright revisions get signed into law, 1976, with the Copyright Act, Public Law 94-553. This was the first major revision of the copyright law since 1909. And this is where we start to see certain exceptions of extensions being put forth, and it was signed by President Ford. And again, as it says, the 76 Act extended federal copyright protection to all works, both published and unpublished, once they are in a fixed tangible form. But as Chrissy has mentioned, as soon as you write something on a piece of paper or take a photograph or create music on it, and record it, it is considered copyrighted, protected. But obviously, you would want to have it officially copyright, go through the process of the Copyright Office to get it registered. So that way, if you were to have to take it to issue to court over who has legal rights to that work, you are protected. Again, it just makes it easier when you go through the courts.
And I also see that this includes unpublished works too.
Mm-hmm.
Yeah.
Well, like you said, Christy, as soon as the notes I'm using here, that you can't see them, but the notes I used, I tried to note down to my wife, that's copyrightable, technically. But again, if someone comes along and says these notes are mine, now, and I want to take them to court, it would be in my best interest to make sure those items had been registered through the Copyright Office, so I have proof that those items were mine and not just someone else's. So things to think about. So what are some of the things that we see that came with that new change in the law? This is when we see the term limits for renewal, period of life, author plus 50 years. We start to see the Congress has altered the renewal process for works copyrighted between 64 and 77. So again, that was that gray area where they fell under the previous law, and they modified it. And a lot of this we saw happen with Walt Disney and some of the material that he created with his artwork and stuff, and the cartoon, Mickey Mouse and things like that, that fell under the the second version of the law, excuse me. And as this new law came about, the extensions to keep the mediums under his their control, as they say. And this, as Christy mentioned, the Sonny Bono Copyright Term Extension Act. Again, this was not a law by itself. This was an extension of the Copyright Act and it was enacted in 1998. And the term basically gives you terms of life of the author plus 70 years. So we saw in the first half of the law, when the law was originally created, rewritten in 76 and signed, it was plus 50 years of the author. Now with the Sonny Bono Act, the author has 70 years, life plus 70, and also 95 years from the life of publication and 120 years from the creation, whichever is shorter. Again, who decides this? Again, I leave it to the courts and the judges to make those decisions. But yeah, with the Sonny Bono Act, and again, as those who don't know, Sonny Bono, a musician, Sonny and Cher. So a lot of the music that they had created when he was a singer and songwriter, they wanted to make sure their music was protected. He had become a congressman, and when he passed away, they enacted this act so the work would be protected. And it's pretty interesting, the history behind it. I won't go into details, but it was pretty interesting reading the congressional record as they discussed this topic. And that's another thing that you have access to in the congressional record. So any of these interesting laws or things that have been discussed dealing with copyright on the floors of Congress, you can always go back to and read up on them. So here we see a court case. This was Mazer versus Stein. Supreme Court holds up that works of art that are as useful articles may be copyrighted. So in the image of the two statuettes, they look like statuettes, but actually they're part of a much larger of an item. They're part of a lamp. And this case went to before the Supreme Court March 8th, 1954, and the bottom half of the lamp was considered copyrightable as works of art or tangible sources, even though the item itself, the lamp in itself, cannot be copyrighted, but the image or the statuette part of the lamp could be. And I also put in, those who've seen The Christmas Story, and I know they played on TBS every Christmas, all can remember that leg lamp that the father won. That's this law, or the Supreme Court upholding of the arts and embodiment and useful articles would be copyrighted. The leg itself would be the copyrightable material. I just thought that was, a funny way to showcase this enactment or this law, excuse me. So if you have any unique lamps that have statues, artwork part of the lamp itself, they are copyrighted. Interesting to know.
Okay, Larry, just to give you a time scope, we got 13 minutes left.
Okay.
Thank you.
No problem. Real quick, so here we started to see in 1980, what's it called? The copyright. They begin to copyright computer programs. 80s is when you start to see those home computers and software to be created. So all those programs that we were using on our home computers then become copyrightable, as well as, and then December 1st of 1990, the computer software rentals, so the software that were able to be rented out and leased, but were copyrighted and were protected. So now we get into the second half of the 20th century, and as Chrissy mentioned, the DMCA, Digital Millennium Copyright Act, went into effect. It was signed by Bill Clinton into law October 28th of 1998. And there's the provision 1201 to 1205 under Title 17, and it makes it illegal to circumvent technological measurements to prevent unauthorized access to copying of copyrighted works, particular books, movies, videos, video games, and computer programming. So now it's no longer able to copy your, cassettes and DVDs. Technically, we would be breaking copyright infringement laws. The whole issue with Napster would be coming about around this time period, and this was a hot case to was discussed in courts. But how does it affect education? So, of course, the DMC frequently applied to copying and showing videos and other online content for our teachers and other nonprofit organizations. And this is where with the law creates certain ways to circumvent the law, because again, in our case, we're not showing these videos to make a profit onto ourselves, but to show them for educational purposes. And here we see in so the careful review of the law and the balance of it. Again, this law was really while it's protecting the commercial aspect of the product, the digital, the streaming video, music, and renderings of such tangible sources. This is where the education settings turn to kind of circumvent those protections, again, because of the nature of the way the material is being used, both as a scholarly and creative activities to instruct a class. So we're in the 21st century, and we start to see things like the Commendament of the U.S. Copyright Office and Practices. Again, they begin to shape and look at long-term improvements of the law. So that's one thing they're working on. We see in October 11th, 2018, the Hatch-Bob Music Modernization Act, looking at how music is rendered and licensing, dealing with licenses now and copyright aspects of digital music. And this is dealing with pre-1972 music. So music, prior to 72, who owns the licensing of those materials if they've been digitalized and things like that. Okay. And then a few quick things on this slide here. We have, January 15th, 2003, the Sonny Bono went before the Supreme Court and in the Alford versus Ashcroft case, and it upheld the Sonny Bono Term Extension Act. So the Supreme Court has ruled on it, at least at that date and time, to the constitutionality of the act itself was okay. Also, in 2025, 2014, this is when we saw the Supreme Court upholds the American Broadcast Companies versus Ariel. And this is dealing with online streaming and customers having to paying customers works was a transmission of the work to the public. So there's many interesting laws, and of course the Satellite Television Community Protection Act of 2019, as far as who has the rights and the legality to put things on our airways, again, before the Supreme Court. And I'm sure there's a lot more of these cases are going to be going before the lower courts and the Supreme Court as more and more digital and streaming services go online, and how things are changed, and we review our materials. So here, it all started with the Constitution, and as fluid as the Constitution is, we're able to amend it and change it as it's over 200 plus years. So too as the copyright law. And that's the one thing I wanted to leave you guys with today. The copyright law is a lot of gray area. It has changed over time as new tangible sources have come about. New things had to be written into the law to be so they can be protected. And who knows what new tangible sources, resources lie before us in the decades to come. So Chrissy has put this slide together. It's additional information, where, if you really want to get into the nuts and bolts, there's always the copyright.gov, great website, government resource. Chrissy's put together a very strong copyright LibGuide, and she's always adding new material to that, as well as the scholarly communications. And she has the copyright, and she'll have these videos and handouts as we create more of these masterclass series workshops. They will go there. So if you ever feel like you're just not sure about copyright, or you just want to feel bored one night, You can always pop on and watch a video.
Yeah, I wanted to, can you go back real quick?
Sure. Mhm.
Yeah, I just wanted to add that for the second bullet for the copyright LibGuide, this is geared for staff, students, and faculty alike. These are just like general authoritative sources and explanations of copyright. But the Scholarly Communication Toolkit, which is the second to last one, recommends sources of copyright information with a library emphasis. So the bullet number 4 is for us, really for us, for our own education, continuing education, if we want to see how it could apply to our respective areas, whether you're in reserves or e-resources or what have you. And I also have links to other trainings that you could attend to if you want to deepen your awareness of that. And then, and the third bullet is copyright for teaching and learning. So this is how copyright can apply to instructional settings. So if somebody has a class and they want to know if they can distribute a PDF of an article, well, what are some possibilities? You know, so we kind of break it down into those more specific areas there. So, and yes, the recordings and the handouts will be available afterward, so for everybody. So, all right, thanks, Larry. So.
You're welcome. And here, please provide us the feedback. If we did a great job, that's great. If you felt, we could have done better, or even if there's a topics you'd like to maybe our working group to add and do later in the year or next year. Again, as fluent as copyright is, and we're not experts on everything. So if there's something we didn't cover or you would like to see covered, just drop us, add it to the palette and give us your feedback. We appreciate it.
Yes, please.
And as Christy mentioned at the beginning of our session, more detail, like I think like you said, Tom is doing the next one on fair use. So the future workshops that we do will be more geared towards individual topics and have different insights to those areas as well.
Yeah, we were hoping to provide some basics so that once we do go on those topics like fair use and course reserves and things like that, that we'll have these fundamental underpinnings in place so that you could understand those areas more confidently. Also, I wanted to add that our next one will be on fair use. It's going to be Tuesday, February 23rd at 1:00 p.m. I'll send an announcement again, although I did send the links to it in a previous email. So you're all welcome to do that. But we're going to change this one up a little bit because 2 days later, on February 25th, we're going to have a follow-up session so that everyone can try a hands-on application of fair use, kind of like what we did for that mini three scenario exercise that we did after my piece. So everyone is welcomed, and we'll also be making the handouts and the recordings available to everyone. Let's see, were there any questions or comments before we close or wrap it up? You could say in chat or any other way. But I would like to thank the Copyright Working Group for helping with all of this. We've been meeting about once a month since I think October maybe, and we've been talking about different topics that the library may want to learn more about in terms of copyright. So things we've got on the hopper are fair use. We'll be talking about course reserves eventually and interlibrary loan. And there was talk about maybe doing something about archives and special collections down the road too. So we will be covering other sources that have to do with libraries and hopefully things that can help you feel better about making copyright decisions or feeling more informed about it. So, Larry, do you have anything else you wanted to add or close with?
Sure. We're learning this as we're no more experts than you are. We just maybe have a little bit a leg up because we've worked with it a little bit longer. When we work with faculty and tell other questions for copyright, we always tell them, look, we're not copyright lawyers. This is our opinion on things, how we understand it or interpret what's going on. And at the end of the day, we leave it up to the person who's came with the question to actually, if they have a more serious issue, to deal with and get a copyright lawyer and things like that, because we're not experts.
I mean, we could help clarify the definitions, show them where the information is, ask them details about their use. But ultimately, we don't make the call. It's the person that does, and they're the ones that will think about their risk and what they're trying to do. So absolutely. Yeah.
And again, just thank you everyone for attending.
Yes, thank you so
We
much.
appreciate it. And again, as this gets put up on the website there, if your colleagues have questions about copyright, just send them the link, let them watch the video on their own.
Absolutely. And thanks to Tanessa for helping recording this and getting the Zoom stuff started too. So, thank you, everyone. Thank you.
Yes. Thank you.
Okay.